Read it up a little bit.
Just a little.
Right at it.
Okay. All right. We're here with Judge Dib Waldrop, and he is running for the Court of Criminal Appeals, Place 8.
Correct.
I am John Wirtz, and with me is Del Fessenden, Dennis Tibbs, and Pat Tibbs. And Judge, as we discussed, we'll go ahead and start off with a 5-minute opening, and then we'll go around the table after that with Q&As.
Very good. Well, I am Judge Dib Waldrip, and been on the district bench for 11 years, and previously was the district attorney in New Braunfels for a period of 10 years prior to that, and was a police officer before I went to law school in 1987. And so I will be the only candidate, one distinguishing characteristic in this race that has the personal experience to be able to catch them, clean them, and cook them. And but in addition to that, have worked for the Courts of Appeals right out of law school, first in Amarillo and second in El Paso. And when I went to Amarillo, I worked for a single judge as a briefing attorney, is the terminology at least they used to call it, and was hired as staff counsel and by and through the recommendations of the judges there in Amarillo. And it's one of the things that is very special to me is just knowing that life is really about relationships and experiences, because that's the only thing we can really take with us, and nothing more. And so I developed those good relationships there, such that I was fortunate enough that they pushed me to go to El Paso to take that higher position, the Courts of Appeals as well. Through some other relationships, after a year and a half of being there, a mutual friend of another man who had been elected a district attorney down in South Texas asked me to consider running his narcotics task force. And I did that for a short period of time, and then after about 8 months, there was a district judge that I had grown up with his family in New Braunfels, Robert Pfeiffer, who had known what I was doing and thought it was too dangerous, and it wasn't all that safe, but I could stay out of harm's way for the most part. But from his perspective, I had invested way too much in my legal education to be doing that kind of crap, in his words. But he said that the district attorney had fired his assistant, and that he had arranged for me to have an interview tomorrow at 10 a.m. And I just said, yes, sir. And so I went back home to New Braunfels, that's where it was, and became the assistant district attorney, and did that for three and a half years. And during that period of time, even as the assistant district attorney, I was able to become board certified in 1995 in criminal law. And I left that test. There's some criteria I don't recall off the top of my head, but you've got to do so many trials and so many appeals and be able to then pass a test. And I took that test and walked out that door in 1995 and said, there is no shame in flunking this pup. But I understand that was the hardest. That was much harder than the bar exam. And glad to get that behind me, and I did get board certified the very first try. And in 1996, did run for district attorney there in New Braunfels, Comal County, and was elected, and continued that. During that tenure, Governor Bush also nominated me to attend the FBI's National Law Enforcement Academy at Quantico, and was able to complete that as well before becoming district judge. But several things, just along the way that I also accomplished was a lot of things that I'd like to see myself as being a solution finder, a solution builder, not just looking for problems. Within the law, as written, that's what a judge is supposed to do, but at the same time, we don't just have to stay up on our gerbil wheel, as Albert Einstein would say. That's the definition of insanity. If we just keep doing the same thing, expecting a different result, and I guess all gerbils are insane. But My point being is that, you know, we did different things with, one of the latest things that we did in Comal County, which is the very first one in the nation to do, every county has indigent defense that they have to do. And so typically everybody uses a wheel, and the attorneys that are on that wheel, just they're all of a sudden going to get their meal ticket punched every time they come back to the top. And some are good, some are not as good. But by using client choice as opposed to a wheel, those same defendants that are found to be indigent get to pick from the same pool of attorneys that used to be on the wheel. And so that forces those attorneys to do a better job, because there is no faster line of communication than that line of those defendants when they go back to the jail, if they're still in jail, or even outside of the jail in that community. It's just like y'all are endorsing candidates, and I promise you they endorse the better attorneys. And so by forcing those defense attorneys to get better, it forces the entire criminal justice system to not only get better in the sense of not just efficiency, but also effectiveness, and becoming more proficient, sharpening the saw. Sir Isaac Newton said one time that, you know, if left alone, all things deteriorate. And so we've got to find ways to make everything better.
Okay, all right, great, thank you.
Do you want this?
In our, thank you. On the questionnaire, please describe the qualifications and experience, of course, that you just went over. At the end, you had mentioned improving and developing the entire criminal justice system with specialty courts, free market economy approaches to appointment of indigent counsel. Is that kind of what you were just explaining there at the end? Okay. All right.
And not the specialty court, but that's another.
Touch on that a little bit, on the specialty courts.
Again, we expect criminals to get better. If we're not trying to put a stop to what they're doing, really put a stop to what they're doing, we're just spending money. So the criminal justice system for years has used only 1/4 of the tools in their quiver, meaning that they've only given a sanction. There are times when you can maybe get some mileage out of taking a sanction away, if you will, to increase longer term, better behavioral modification and in the way that we think it should go. There are times where we maybe should give an incentive, not necessarily a reward in those terms, but maybe an incentive to do better. And then there's times where in the mode of your operation, you should take incentives away. And so, but historically for years and years and years, the criminal justice gerbil has been on that wheel merely giving sanctions. And so the specialty court model that has proven to work very well, there's scientific data to that effect, uses all 4 of those options of that 4-pane window, if you will, to try to get below the surface. Not just put a Band-Aid on a blister, but to try to actually figure out what is the thorn that we need to remove. And not that the criminal justice system is the do-all, end-all caretaker of society at all. But we too, in the system, need to do a better job to help criminals stop committing crimes. And so if somebody is addicted, it is defined medically, professionally as a mental illness. And so we need to figure out what we need to do to help remove that thorn of mental illness from, as opposed to merely putting them in a warehouse where chances are that mental illness might just get worse.
All right. Okay. Thank you.
Okay. Of the judges currently on the Criminal Court of Appeals, the 9 judges there, including the incumbent, which one rules most like you?
Well, they tend to be all rather conservative, the most moderate, if you will, or most liberal, which would be farther from me, would probably be Judge Alcala, who's seen to
Okay.
replace. But I would say that probably one that is most like me is probably Bert Richardson.
Okay. Good enough. Is there any Court of Criminal Appeals decision in recent time, well, could even be further back, but that you actually disagree with?
Yes, sir. Sure.
Okay, could you elaborate on that, please?
The one that I was personally involved in was one where the statute, the Code of Criminal Procedure, section, I believe it's 26.14, says that if a criminal defendant persists in entering a plea of guilty, that a jury shall be impaneled to assess punishment unless the defendant has waived, pursuant to 1.13 of the Code of Criminal Procedure, a trial by jury, and 1.13 requires the state's consent to waive the jury trial. But then there's an or, and it says or under 3707 has elected to go to the court for punishment. And it's a grammatical problem in the construction of the statute. And the Court of Criminal Appeals read that to mean that the state had to consent to the election if they persist to the election of the defendant to go to the court, which
would that be a safer interpretation?
well, it's just criminal defendants go to the court for punishment all the time. Actually, if they go to a jury trial and they fail to elect the jury, state law says that the default is to the court. And in that particular case, the defendant had not only, I guess, acquiesced in that default, but had actually filed a piece of paper electing to come to the court. So they're kind of belt and suspenders. But yet he was willing to plead guilty, and just the court read that where it said waiver because 3707, that part of the statute is not a waiver statute, it's the election of punishment. And so I don't know exactly what you meant by the safer. Well, I just read it if a defendant has chosen to go to the court, he's entitled to do that. And what it does is, unfortunately, it creates a system where that if that's what a defendant wants to do, they have to go up there and pick a jury, waste everybody's time, everybody's resources in doing all of that, so to speak, and then stand up and plead not guilty. But then in opening statements, the attorney can say, I know my client just pled not guilty, but actually, in actuality, he's willing to be the state's first witness, and here's all the discovery they gave us, and we agree to mark that as State's Exhibit number 1, because my client will tell you that he's guilty.
Okay.
But he has
just... For the sake of time, I think that's kind of along the lines of a satisfactory answer that I was looking for.
Okay. It sounds like you got out of law school and went to work for the Court of Appeals. A lot of judicial candidates will boast that they've had time as an attorney for the defense and experience as attorney for the plaintiffs, and that works to their advantage. So would you say that, and you didn't work in private practice, right?
Correct. So
How would you say that that's a good thing or a bad thing going directly to a court?
Well, I would say that the breadth of the experience, everybody's going to have different either narrowness or breadths. I think having been at the Court of Appeals, you see both sides, the defense, the prosecution, and there's times when the law requires that the defendant is going to win. There's times, more often than not, people get it right, judges, juries, and everybody else get it right, done right. But I have seen both sides, that having been the district attorney as well, I've personally tried over 100 felony jury trials. I was not willing to take a case to a jury unless I personally was convinced that the evidence I believe to be admissible and available for proof at trial did prove beyond a reasonable doubt that a person was guilty. Liberty is our most cherished freedom, and don't take that lightly from anybody. And so was able to discuss things with defense attorneys. And so to a certain extent I've had that perspective, and having been a person who, as I said, only willing to take a case to trial that truly was guilty. If there was any question whatsoever, then we find a solution to that problem. And but I think the breadth of my experience is certainly going to, at least in this race, with the two opponents that I'm going to have, is going to be broader than anybody else can bring to the table.
All right, thanks.
On one of the questions on the category of general, it's please describe the changes you will make to improve the efficiency of your court, yet remain thoughtful about rulings and orders that allows all parties to be heard and their arguments considered, which you've been talking about this morning. In a ruling on November 23rd of last year, retiring Judge Elsa Akala, the judge, of course, for this seat, indicated that the Court of Criminal Appeals is breaching the Constitution, both U.S. and state, of fair appeals hearings by not having the required minimum 2 judges review cases for disposition, and that oftentimes it's only 1 judge. And in talking to a couple of attorneys, local, they indicated that sometimes it's only a clerk who, albeit is an attorney, is the only one reviewing and writes a memorandum to the court to decide whether or not the CCA, the judges, are going to hear the case. What are your thoughts about that? Are you aware of that?
I'm aware of that opinion that she wrote. I certainly think, again, that liberty is our most cherished freedom. That's what a writ habeas corpus is designed to, in certain ways, designed to protect. That if our Constitution requires that 2 judges review it, they review it. Now, the mechanics of how they would review it, I can't really speak of, not having been within their inner sanctum. I do know that from the courts of appeals that I've been at, and there are times where they have handled different similar type writs, but not the writs obviously sent to the Court of Criminal Appeals, but that they tend to have a conference. And so my point is that if there's a clerk or briefing attorney, so to speak, that has at least looked at it, that the judges, when we would have, I would ghostwrite opinions for different judges in Amarillo and El Paso. And so then in the conference, the judges would ask us questions and probe why we're making the suggestion that we're making. And I trust that that would also be a similar process. And so, to a certain degree, if that is it should be happening, such that the judge, him or herself, is considering it, and more than one, should be at least 2, if not 3 or 4, right, to be able to do that. And so I think in making sure that everybody is properly heard, I would hope that part of the conference, maybe it's a rotation per week or per month or something like that. I don't know, again, their mechanics. Okay. But such that everybody can be heard and it wouldn't be overburdensome on the court itself or any one judge.
All right. Yep.
Okay, for those of us who are not in the legal profession, which is everybody in this room but yourself, what is the significance, why is it important that you are the only one that's board certified in criminal law?
Well, there are a lot of intricacies, such as one that I pointed out, where that it wasn't a unanimous decision. There are other judges there at the Court of Criminal Appeals, 3, that agreed with me in that situation that we discussed. So it was like a 6-3. Ultimately, I think in effect, a 6-3 opinion. And there's just a lot of intricacies like that that people need to be aware of. that having had the ability to pass that exam, as I mentioned, it was very trying, very difficult exam, and it delves into those. There's always exceptions to the general rules, and knowing those exceptions in whichever way that might dictate the result of a case can be very critical. And if you don't know those very minor exceptions, the law might not be properly abided by in a given situation.
So are all 9 current justices board certified?
I haven't, no, they are not. I was going to say, at first I was going to say I hadn't double checked, but I know a couple that are not.
Okay. Dennis?
Okay, so you've almost had a full career as a district attorney and also as a district judge. Are those both state employee positions?
Yes, sir.
So you're not retired from your district attorney job? That's still an employee retirement program?
Well, they're two separate, the judge's retirement program and the district attorney's retirement program are different.
But you're not retired as a district attorney?
No, I mean, I mean, if you mean am I drawing
Yeah.
retirement? Yes, sir, I am.
Okay. And who is the boss over those two jobs? Who would reprimand you as a district judge or as a district attorney and have the error? Not counting the voters.
Yeah, district attorney, it would just be the state bar. As district attorney, I was not reprimanded. As district judge, I was, because it was a private reprimand that there was just a situation where I felt like somebody was trying to pull the wool over my eyes, and I held an attorney in contempt. And they said that I did it basically too quickly.
And who said that?
That was the Judicial Conduct Commission.
Ah, okay.
Or it may be the Conduct for Judicial, or excuse me, the Commission for Judicial Conduct. CJC, as opposed to JCC.
Okay, thanks.
I get caught up in everybody's questions here, we could get caught up on mine.
You want to pass them to Beth?
Yeah, why don't you do that?
Okay. I've got mine numbered, I just have to find the number 3. Okay, in response to the question, what role should government have in reforming criminals, one of your statements was revisit certain laws and regulations that unnecessarily turn otherwise law-abiding people into criminals, which of course is an interesting statement. Could you elaborate on that? Give me some examples of some statutes that tend to turn law-abiding citizens into criminals.
Well, sometimes there are, and some of it, I think when I was thinking of that in the vein of the statutes that are sometimes well-intended but can be misused, because district attorneys do have the discretion on what and how to prosecute certain things. And just because you can doesn't always mean that you should. There are, like for instance, y'all have experienced the hurricane down here, and there is a statute that allows for certain crimes to be enhanced, maybe to be more severe criminal. Maybe somebody needs to be prosecuted for maybe a lesser offense, but if there's an enhancement available, it can get it up into that felony range where then somebody is a criminal for the rest of their life. They're branded, so to speak, in that vein. That may or may not be necessary. Now, in the sense where what I'm talking about there is that enhancement is if there's a crime committed during a time or in a place of a natural disaster or declared disaster, that it can enhance the punishment. And the purpose of that is so that people aren't being gouged by contractors or being defrauded, etc. So if you commit such a crime, that then it can be enhanced. But that can be and has been misused, in my opinion, where that maybe it's a declared disaster of a drought as opposed to a flood. But that then some crimes can be that have nothing to do with the drought. Just the mere absence of water can and have been enhanced such that those people will then have that brand on them that they've committed such an enhanced crime, so to speak, because of that.
Yeah, we have some out of control government folks that are telling us that we're going to be out of water here next month.
Unless they charge more money.
Unless they charge
And the
more
same
money.
thing can, yeah, the same thing can be true. The other example that I'm thinking of there is with the sex offender registration. That
Okay.
we have a map of Texas on the website, the DPS website, that has little red dots where sex offenders are. But we really do ourselves, as law-abiding citizens, a disservice if all of a sudden, instead of having independent red dots, it's all one red blob. Because you can't tell the sheep from the wolves. And as there are times where people, like I said, there are things that you could allege, could prosecute somebody for an offense. And it all depends on how you present something to a grand jury, which the grand jury, I use as DA, the grand jury, as a sounding board for the community. It's what the community wanted. There's an old saying, you can indict a ham sandwich if you really want to. You know, you can indict just about anybody for anything. And so, but also again, you can present something in a fashion to let that sounding board of the community tell you what is it that we want you to do, Mr. District Attorney or Mrs. District Attorney. And so we had a situation where that there was a 16-year-old football player who fell in love with his 22-year-old student teacher. And the evidence all was that he pursued her and she succumbed to his whims. And not right, but does she deserve a red dot on that map in Texas? I don't know. Point of the matter is, I asked the grand jury that, and I said, we can do other things other than prosecute her for sexual assault of a child. When this young man pursued her, she should have said no. No doubt about it. It was wrong. But she could maybe been prosecuted for lesser things, all the way down like to assault. But the grand jury, and I told them that, there's several other things that we could have prosecuted her for. The point is, as far as the map, talking about that, she's just not somebody that really scares me, and I think that that's what the design, the intent of that is, so that we can figure out where do the people who scare us live, you know, in that vein. And so, but ultimately, they just said, we want you to send a letter to the TEA and tell them that she should never be a teacher. And that's what the grand jury suggested, and that's what I did.
Or are we back to
I
John?
don't know where.
Yeah,
Go ahead.
Eeny, meeny.
Be back here?
Didn't you skip your turn?
Mighty mo.
I did, but I
He'll
came
wake
back.
up for it.
Go ahead.
Okay. Well, I thought it a little interesting that you went to the FBI Academy. How did that come up, and why did you do that, and do other lawyers and judges routinely do that, or were you thinking about being an agent?
No, sir. No, it's not the FBI Academy, but there is. It's called the FBI's National Law Enforcement Academy. It's a 3-month program where they bring law enforcement and district attorney prosecutors from around the country to come to get some specialized training.
And you were a DA at that time?
Yes, sir.
Okay. And is that something that, is that the same one that they would send regular police officers to?
Yes, sir.
And other DAs go to that one?
There are, yes, sir. There was, I think, 2 others, the district attorneys.
Who did your DA work while you were gone? You have assistant DA?
Yes, sir.
Okay. All right, good deal, thanks.
Alrighty. On back to the general questions. Second one, do you think judges should be elected by the people or appointed by a commission? You said fundamentally, I believe the people have the right to vote on all members of government from each of the executive, legislative, judicial branches. Do you think, and you kind of went on to say that when you get below like the statewide offices and you get to the judges, well, all judicial offices, people's eyes kind of glaze over because they don't know really who's a good judge and who's not. And I'll say that our first go around with this last year was a big learning experience because we were asking questions that were pertaining to answers that might violate the Code of Judicial Conduct. So we did have attorneys kind of look over our questions and make sure we could steer through all that. But back to what you were saying, I want you to kind of explain a little bit on your philosophy about, appointed by a commission. And I guess my question is, do you think in general, at least where the judiciary is concerned, that the voting public has the discernment to properly vet judicial candidates, considering most are not, judges are not, and candidates are not political in nature, and have trouble getting their messaging out? A case in point, on the other side of that might be Scott Walker, who just won his position in last year's election. And we're not talking about the governor of Wisconsin, we're talking about a judge here in Texas. And he had no campaign. He was non-responsive to any request to interview by anybody that I know, and yet he won handily because of me. So tell us a little bit more about the appointment aspect that you have in mind.
I know there are a couple of states that do have a commission that creates a pool, and then different states have different mechanisms from them which somebody is selected from that pool. I think some states do it. The governor could do it. Maybe their legislature could vote them in, at least at first or something. And then from thereafter, it could be a retention. And that way you're voting on that, you are voting on that judge, up or down, based upon his or her performance, good or bad.
Does that open an opportunity for pay for play though?
Once you get there, or are you talking about just
To get into the pool?
No, I mean, it's here now, unfortunately. I mean,
Does it open it wider?
I can't say yes and I can't say, I agree with you. I think it would probably make it wider, but at least then if you're trying to get to some form where the people that are voting, every election cycle, when they vote, they have the opportunity to basically look at a person's work and vote them out if they're not following the law as a judge. Otherwise, we're going to continue in this cycle of just the potential, and I don't know anything about Judge Walker.
Right. He could
Good or bad.
Could be a great judge, but
I've seen the campaign, the reports. I think he spent less than $10,000, whereas other people were, yeah. So that definitely took pay for play out. people paid closer to $100,000 and lost.
Yeah.
For their campaign.
It's amazing. It's scary. The
So,
people aren't that involved and they're just going off of a name.
I think one of the other options that I put down on the questionnaire was that maybe we just need to separate. The problem with that is it creates another election cycle, and it would be never ending, another expense. The last thing we need is another government expense. But I'm saying had some way to segregate or separate such that people could focus on that.
Pre-vetting by a qualified board, huh?
Who would do that?
Well, but one of the things I was saying was to do an off year instead of being elected in the even number of years. You have an election in the odd number of years.
Okay. Politically, you contribute to the Republican Party, state, local, national, etc. And then you contributed to Governor Perry, Governor Abbott, Senator Cruz, and President Trump. Now, one of the things that is pervasive throughout your answers is that you have a very strong Christian basis. And I can see, coming from that perspective, contributing to Governor Perry, Governor Abbott, Senator Cruz. President Trump took an awful lot of flack for, shall we say, indiscretions, whatever, not being the strongest moral character, et cetera, et cetera. And so I guess I was a little bit amused to find that you had contributed to President Trump. Could you elaborate on that and clarify that confusion for me?
I too am a sinner,
As we all are.
and I too try to get better. I can only hope and trust that he too, the president, is getting better and sinning less. But whether or not I know that, and I have reason to believe, and I've talked to some people who are rather close to him that said that even his decision to run for president was based on prayer and a response to prayer. Such that, yeah, again, I can only hope that he's becoming less sinful. You know, the veil is being removed. You know,
He's more in the public eye.
But 2 Corinthians 13, or excuse me, chapter 3, verse 17 and 18. For you know, where the Spirit is, there is freedom, and that the veil is being removed, such that we are being transformed into the ever-increasing glory and likeness of God. Probably didn't quote that exactly, but it's pretty close. Point being is that that's what I'm saying, we're getting better, hopefully, if we're seeking the Spirit.
Okay.
And so I hope that he's seeking the Spirit, number one. Number two, my other choice was not very good.
We do understand that. And agree.
So I do what I needed to do to prevent Hillary from getting in there. I didn't know, what else to do. And I was a Cruz guy, so initially. So,
Yeah.
Okay, so where's the incumbent in this race? Is he not running?
Judge Alcala is not running. She's retiring.
Okay.
She's from Houston. I think she has a couple of children that are like nearing graduation in high school, and that drive. I think she wants to be a little more involved in.
Okay. Where is the court of criminal appeals in Austin?
Yes, it is on the north side of the Capitol.
So you'd still live in New Brunswick?
Yes, sir.
Okay. And neither one of the other challengers are board certified as criminal law specialists?
Correct.
Are they board certified as anything else?
Jay Brandon is board certified in family law, but Ms. Slaughter is not.
Okay. And is it possible to be board certified in a whole bunch of stuff? And how many specializations are there?
Cool, there's probably 10 to 15.
No. So somebody might be board certified in more than one.
There are some.
Yeah.
I know of one or two that are even triple certified, and I just shudder to think they have to take that kind of a test 3 times.
Okay.
All right.
You're not going to let her ask any questions?
I'm tired of that.
It's okay.
Like and later.
So what Texas state court decision do you think has most impacted society? How much and why? I think you said you're going to think on that one. It's a very broad topic for discussion. Have you thought of anything?
Yeah, I mean, Texas, from the Court of Criminal Appeals perspective, just make, I don't know that there's any one that I can think of, but to be honest with you, that, it's, I apologize that I didn't come thinking in terms of that. I'm just running all over this state, but
Understand.
I'm most interested, though, in decisions that impact what I call the people's constitution and the Bill of Rights. And so the United States Supreme Court issued an opinion that Scalia did write on frequently on the issue of confrontation. And I think that was a big deal of the Crawford opinion that Rehnquist actually wrote in 2004. And just making sure that people's rights to confront their accusers are abided by. And the Texas Court of Criminal Appeals has written several opinions on that. There are ways to forfeit that right to confront your accusers, and they wrote on that, the Gonzalez opinion, such that if you like threaten somebody to not testify or have harmed somebody or seen to it that they were harmed such that they were retaliated against, then that is one way that you can forfeit your right to confront your accuser. And I think that's a proper and a good law. And it was referred to by Rehnquist in the 2004 Crawford opinion as well, but just in passing. But that was something that then the Court of Criminal Appeals further developed. And I think they got it right.
Okay. Thanks, Bill. Let's see, time-wise, we are about 12:50. We started 12:05, so we got another 5 minutes or so.
Okay, one of the questions with respect to government or court orders directing parents to do things for their children and so forth. Your answer was basically in support of parents, which is what I would have expected your answer to be. Can you give us your current thoughts? There's a lot of controversy now about vaccinations being required for admission to school, etc. So how do you see that? Should schools require, should they refuse admission to unvaccinated students, etc.?
The answer is probably yes and no.
Thank you.
Well, there needs to be a correlation. If the mere fact that students are in a classroom together, like we are here, exposes another student, or could expose another student just by breathing, maybe touching, if that exposes student by student by student to catching some disease, by the mere fact that they're in a classroom together, then maybe there could be a requirement. But if there's some vaccination for something out there, that the mere fact that the students are going to be in a classroom together, they're not going to get it, then there's no legitimate basis, there's no nexus for the requirement that they be immunized, and the parents then should have the ability to choose or not to choose if that's something they want for their student or their child.
Okay, I could go a long ways with that. For instance, one of our children had a reaction, and this has been over 30 years ago, had a reaction to a vaccination, and the medical doctor said, I'm not going to give any additional vaccinations to this child. So in that case, if the school said he had to have vaccinations to be admitted, and we said, no, you're not, I'm not sure what course that would take.
Yeah, I don't know if there would be a way to craft an exception for, there's a medical need there, a medical excuse, such that maybe there should be an exception. But I'm just saying that if you have 30 students in a room and there's some, I don't know what, maybe it's the measles or something, I don't know, or mumps or something. that they can get just by their close association with each other.
Most things are like that.
Well, but there are vaccines out there that have been required for different things, that sexually transmitted type diseases. That better not be happening in the classroom, right?
Well, hopefully there wouldn't be mandates for that, is that right?
Exactly. Well, but that's why I'm saying the answer is yes, sir. I'm just saying there are vaccines.
Like Governor Perry attempted, what was it, 98 or whatever it was?
Yep, I was not impressed with that.
Okay.
Okay, one of the biggest issues to citizens these days is that civil asset forfeiture. So, and to what extent is that done totally autonomously by police departments, and how often do those things get into a district court, or do they get into a court of appeals? And the way I understand it now, the law enforcement says, you're a criminal, this boat car house was used in committing the crime, and we're taking it.
Number one, it would be a civil lawsuit. So it would not end up at the Court of Criminal Appeals. It would end up at the Supreme Court by way of the division of the work.
You go to the Texas Supreme Court.
It's called an in rem, I-N, in other words, R-E-M proceeding. It's about a thing as opposed to a person. So the lawsuit is always filed, the state of Texas versus a Harley-Davidson motorcycle.
That would be filed by the takee, the person who lost the stuff, right?
No, it would be filed by the state. The state has to, law enforcement, if they see something,
They got possession of it, right?
they have possession of it.
Okay.
Then there's a process under Chapter 59 of the Code of Criminal Procedure in which they have files and affidavits, and within certain time frames, file that in rem lawsuit against the good, the contraband, and they have to file an affidavit saying why they believe it to be contraband. And the current law says they have to prove that it fits within the definition of contraband. Either it was used or that it was gained from the commission of certain crimes, or used to facilitate a certain crime, or with the illicit gain.
And we hear so many times that that's done before anyone is convicted of a crime. Does that mean that even though they're not convicted, they're fighting it just, or they won't fight it just because of the expense of the lawsuit?
That's certainly one option. But also, in order to fight it, they probably would have to testify. That testimony would be recorded. It might be used against them later on.
If they did something, yeah.
If they did something. So, I don't know. But right now, it has to be proven by preponderance of the evidence.
In the district court, you would see some of those
Yes,
cases?
sir.
Okay.
Yes, sir. Usually, they end up not being challenged.
Not being challenged by the person who owned the property?
Correct. I don't know that I've ever had. A lot of times, it's just a default. They don't answer.
Yeah.
Period.
All right, the rest of the case.
One more question. Amazing one. Do you believe in term limits? And if so, how long do you plan to serve?
I do believe in term limits, and that's one reason why I'm actually running, even for judges. And so I would see myself maybe being in the position, maybe 2 terms, no longer. If I were to remain longer, it would, in my view, it'd have to be like at the presiding judge level or something.
Okay. So at this point, give you up to 5-minute closing unless you want.
If my voice will hold out.
Unless you want us to fire more questions at you, but it's your prerogative on, how you would like to close out.
Well, I'm certainly entertaining any additional questions that either of you may have, but again, I do appreciate the opportunity to be here and enjoyed the meeting the other night. We'll likely come back, but just kind of the big thing is I've said that I think that people have to think, whether they're a district attorney, whether they're a defense attorney, whether they're a judge on a trial bench, you have to have that ability to think and be within the confines, the makeup of the law. You have to be able to find solutions to problems, as I mentioned before, and to try to find ways to make the system better. And you don't just have to just blindly just follow a path like sheep running off the cliff, so to speak, if ever, you know what I'm saying? Same thing is true with the forfeiture. I think we can find one. I understand the issues and I understand the problems. And there probably can be some ways that it can be corrected. There are times when somebody who might be criminally liable for an offense might flee the country. You know, and so chances of ever getting that conviction are slim and none. And so they can go forward and maybe try to just forfeit whatever property might have been seized. I mean, that's one, you know, extreme example. But to try to protect that, to find a better solution, maybe instead of preponderance of the evidence, we require that it be clear and convincing evidence, a higher standard of proof. Or maybe it could even be proof beyond reasonable doubt. It's whatever the legislature wants it to be, to take somebody's property. You know, my point is we can find a solution to make it be appropriate and work for the good of the people, the entirety of the people. But just generally speaking, again, as I emphasized earlier, I've always, whether it's been district attorney or whether I've been district judge or a police officer, been very protective of the Bill of Rights, such that we all have the right freedom to speak, the right to bear arms. We also you know, have the right to Third Amendment, hopefully we'll never have to use, but just so we won't have to quarter soldiers. It's been a long time, I guess, since anybody was ever asked to do that. But the Fourth Amendment says that we can be secure in our persons, places, and things. And that's part of what you're talking about, the concern there. Or the Fourth Amendment, the Fifth Amendment, the due process, the Sixth Amendment, right to counsel. You know, the Seventh Amendment is the right to a jury trial in a civil matter as long as the value is over $20. And Eighth Amendment says that we're not subjected to cruel and unusual punishment.
Except for the 16th Amendment.
Well, I'm talking about those first 10, and get to the 10th Amendment especially, where I think that the states should have the right to choose certain things that the federal government is not explicitly given those authorities.
So you, would you agree with interposition or nullification?
Well, no, I think that juries are the ultimate sounding board, isn't it? Even the grand jury, the ultimate sounding board for the community. And defense attorneys oftentimes do a good job, but could do a better job, in my experience, in explaining that in a legal way to jury panels, because you have to, you know, your definition, your belief, your understanding of a term and whether the proof establishes that. If it does or does not, you in effect can nullify what you believe to be, in other words, a law that might be too lax.
And that would be as a judge and not with a jury, right? Yeah, you have no problem.
No, I can't, as a judge, I don't know that I can nullify a law, but I think that the citizen, by their vote, and can be one of 12 to say, no, I don't think that's correct. I don't think they can establish their proof. But anyway, I don't know how that really gets to the 10th Amendment. I didn't really catch the nexus.
Yeah.
To the 10th
enumerated powers, right, by the federal government. And
oh, okay.
If it's not like in the Constitution, then, you know, I think by and large, we as citizens, or even, you know, be my opinion, the judiciary may have the opportunity and power to nullify a particular ruling that's not, that they don't believe is constitutional.
Well, we have to be in a situation where it's presented to them, and there'd be a good faith argument such that they could, if trial judge is willing to, you know, believes that the law and the facts is presented, you know, may challenge a certain situation with some precedent. They can, if they can explain why and are willing to explain it and hold that way. In effect, it's not really
Like
In that
Obama-
sense.
Yeah, like Obamacare or Burgerville, yeah.
Those are, I guess, we could be here a long time. We sure could. Anyway,
Okay, well, thank you very much for coming in and participating in our process, and what we'll do is ask you when Dennis